Tonight on the Daily Debrief, a federal judge agrees that an accused millionaire pedophile poses a high risk of fleeing before trial. And new documents indicate who was talking to who else about Donald Trump and Stormy Daniels. Also, a verdict in a military love triangle murder trial, where a defendant's mother couldn't believe the charges.
It's like to sound like a TV show, a dream. No, they're not lying.
Plus, bruises on a child.
It was an odd appearance, didn't look right.
Did she choke to death or die from abuse? The Daily Debrief recaps the day in court. It's Thursday, July 18th.
Good evening, everybody. Welcome to the Debrief. These two stylish gentlemen are Brian Buckmire and Mike Koribanics. We'll be with them in just a moment. The millionaire sex offender accused of a series of new federal crimes will not be released on bail before going to trial. Chief Investigative Correspondent Brian Ross is following the case against Jeffrey Epstein from the newsroom for us tonight.
Good evening, Aaron. Well, Jeffrey Epstein tried everything he could to stay out of jail while he awaits trial. He offered to put up his $77 million mansion, his private jet. He offered to hire bodyguards with arms ready to tackle him if he tried to flee, to wear a GPS ankle bracelet. The judge was having none of it. Prosecutors said that Epstein had limitless resources to flee. He was facing up to 45 years in prison, and there was also the risk he might try to tamper with witnesses against him. So the judge, Richard Berman, ordered Epstein held. He'll stay in the Metropolitan Correctional Center here in New York until the trial begins. We're covering all that tonight on our program, The Brian Ross Investigates. Also, Aaron, the fascinating story that's almost exactly eerily similar to that of Epstein, involving a California minister who runs a church that claims to have 5 million members. He also is charged with the sexual abuse of underage women. He also is being held without bail. We'll get into all of that tonight on Brian Ross Investigates. Aaron.
Brian, we'll see you here on the network in about a half an hour. Documents released today are detailing the FBI's investigation into hush money paid to porn star Stormy Daniels to keep her from speaking about an alleged affair with Donald Trump. The documents outline a series of phone calls and text messages involving Trump attorney Michael Cohen, Daniels attorney Keith Davidson, Trump campaign press secretary Hope Hicks, then candidate Trump, and 2 executives with the parent company of the National Enquirer. The agent who reviewed the calls wrote, "Based on the timing of these calls and the content of the text messages and emails, I believe that at least some of these communications concerned the need to prevent Clifford from going public." Clifford, of course, is the real last name of Stormy Daniels. Michael Cohen pleaded guilty to campaign finance law violations in connection to the payment. President Trump admitted in a Fox News interview that the Daniels hush money came from him personally. An update now to breaking news we brought you yesterday here on the Debrief. A Massachusetts judge accepting a prosecutor's request to drop a sex crime case against actor Kevin Spacey. The prosecutor said the accuser was unavailable, and that's because the accuser pleaded the Fifth, refused to say what was going on when he was asked if he played a role in deleting text messages from his phone, which could have been favorable to Spacey's defense. The accuser's attorney reacted only by saying that the accuser and his family showed an enormous amount of courage under difficult circumstances. So with us tonight are attorneys Brian Buckmire and Mike Koribanics. Let's talk about this Kevin Spacey case. I say too many legal risks here involved with this witness, the disappearing evidence. The prosecutor did the right thing. Brian Buckmire.
So yeah, you have to remember, and as jaded as I am as a public defender, prosecutors have what's called an ethical duty. If they do not believe they can prove their case beyond a reasonable doubt, they have, as you elicited so many times yesterday during our CLE, they have rules of ethics and duties to make sure that they are seeking justice. And if they cannot reach that, it's their obligation to dismiss the case, or at least ask for it as they did here.
A risky case, exactly. That's why they dropped it. I think they did the right thing. Let's talk about the Epstein case here. Mike Koribanics, right call to keep a guy who has a private jet locked up before he faces trial on serious charges?
It's a right call, and it's also a legal call. Even more so than the private jet, is you have someone who is supposed to be on sexual monitoring, and when they hit on a warrant on his premises, yes, child pornography. I think that really is what really moved the judge to make sure he didn't get out.
So the risk of a possible offending again here, that might be a big issue. Let's talk about this Michael Cohen thing. We've got this new information coming out, Brian Buckmire. Everybody's talking to everybody else according to these memos, and yet for how many months the narrative has just been to try to distance it. It's just Michael Cohen, and this issue just keeps coming back up.
I mean, use whatever analogy you want, sinking boat, burning building. At the end of the day, everyone's trying to get off this and trying to say, this is this. The other person, I have the least or no connection to this, and I think you're trying to point the fingers at someone else rather than yourself.
Exactly. Okay, that's why I lined all the pictures up, because that's what the documents released today indicate. Everybody was somehow communicating in close proximity. Let's move on and talk about our trials now. A Michigan jury deliberated for only about an hour this morning before delivering a verdict against a woman charged with plotting with her lover to kill her own husband. This is the case of a so-called military love triangle. Kamaya Hassel has been convicted now of encouraging her lover, Jeremy Cuellar, to murder her husband, Tyrone Hassel III. Here's the reading of the verdict.
If you would please read in count 1, your verdict.
Guilty of first degree premeditated murder as aider or abettor.
Thank you. And as to count 2.
Guilty of conspiracy to commit first degree premeditated murder.
One of the key pieces of evidence was a police interrogation of the defendant where she confesses her involvement.
Right. I said, did you plan with Jeremy to kill Tyrone? He said, yes. I put it in quotes to go and put your initials there. Did this plan start in Korea? I think that's important. He said, yes. Is that correct?
Yes.
Right. Was the money part of the reason for the murder? You said yes. Did you try for 4 days to work together to kill Tyrone? You said yes. You might want to write it, why didn't you do it? Because there were other people, right? There were other people right in there. Maybe we didn't do it because there were other people. So we showed that you didn't want to shoot somebody innocent. Did Lieutenant Gusky threaten or promise you anything? You said?
No.
Okay, go ahead, Mr. There. Is there anything else we need to tell?
We were sexual.
That you were sexual? Okay. Yeah, because that's kind of how you guys, that's how the relationship goes, that level that you really shouldn't get to, because then this stuff kind of happens, you know, whenever you start thinking.
And that's why Jeremy didn't like him. Because, well, that's why my husband and Jeremy didn't talk.
Did Tyrone know you guys are sexual?
No, not because of that. So one day me and Jeremy were talking and he complimented me. And at that time we weren't sexual. We had never seen each other outside of work because we were just talking. And Ty saw it and he was like, I don't want you talking to him no more. And that was the reason why they weren't cordial.
The defendant went on to express remorse.
Was Jeremy getting cold feet?
I don't think he was getting cold feet.
And so he didn't want to do it with somebody with him.
Yeah.
You didn't want to take out somebody who didn't belong, you know what I mean? You wanted Ty gone, but you didn't want to hurt somebody innocent. That's you know what I mean? That says something for you. There are a lot of people who just shoot everybody. You know what I'm saying? So, as far as now, are you sad that you planned this out with him?
Yeah, that's why, even though I wasn't being 100% truthful in the beginning, that's why I kept saying that.
When you say you weren't 100% truthful, that's a kind of a major 100%. You were 25%. Would you agree to that? I mean, that's huge. I mean, I almost think with these guys,
But that's why when I kept saying that, with what I know now, if I could, I would go back and not do it. I wouldn't even talk to Jeremy at all, knowing that everything would have gone like this.
But Jeremy was going to go and you called him back. You know what I'm saying? And I get why you called him back. I mean, knowing now, what do you think should happen to you right now?
I don't know. Because myself, I feel just as guilty as him.
Wow. The defense unsuccessfully claimed that the interrogator was the one pushing the defendant around during that interrogation. You saw why that was unsuccessful. But that whole explanation doesn't explain how the defendant appeared to cover her tracks by deleting her Snapchat account.
Now, sir, did you become aware that Snapchat was possibly involved in the commission of this murder?
Yes.
In doing the extraction from Kamaya Hassel's phone, did you do a search for a Snapchat application?
Yes.
Was there any Snapchat application on her phone?
No. I thought that was odd that it wasn't there, and then going through some other parts of her device, which included the search history for the web, there was a search for how to delete Snapchat on there. The first one on that screen happens to be an active duty soldier killed on New Year's Eve.
And then the next search on that screen is January 2nd, 2019.
Yes, and that's how to delete Snapchat Google search.
And what happens when you delete your account?
After 30 days, the information is completely eliminated off not only the device, but off of their servers as well, which is where they store all their information. Snapchat had nothing to produce for us that we requested, no information.
No evidence of any records?
Correct.
Before the state wrapped up its case, the state played jailhouse phone calls between the defendant and her mother. In this next call, the defendant tells her mother what charges she faces.
What are you being charged with?
They said an open murder charge.
No, you're open. You've been charged with murder. Come on, is somebody coercing you to say this stuff? Because this graphic sounds like a TV show, a dream.
No, they're not, Mom.
I can't hear you.
No, they're not. I feel terrible, Mom. I just wish it never happened.
In another phone call, which was very hard to hear, authorities claimed they had evidence that the defendant admitted to her mother that she helped plan the murder. So, Brian, Mike, why did it go to trial? Mike Koribanics, your thoughts?
Well, sometimes, in a case where you're killing your husband, lover, it's very difficult to really come out and admit that. And this may sound like, an armchair psychiatrist, but I think sometimes people don't want to admit it, but know they're guilty of it and just want to hold it to the process.
Yeah, I had another thought with it, and perhaps Mike will agree or disagree with me. It was just something sterile. It was like I was watching somebody buy a new car, like, check this, you're agreeing that you played a role in this. So she basically legally admitted to it all. We listened to it over and over again. Is it possible that this went to trial because there really wasn't much of an offer?
Yeah, and so for the most part, things go to trial, at least in my experience, and Mike, you can agree or disagree, it's one of two reasons. One is your client's decision, and as lawyers, we cannot refuse that decision. If they want to go to trial, they go to trial. Or two, the offer is at a point where they cannot take it. If the offer is life and the max they can do is life, then the answer is I'm going to roll the dice and go to trial. And I think those are the only two reasons that could apply here.
And Mike is agreeing here. Maybe hoping, maybe there's going to be a lesser. This wasn't a lightning fast verdict, but it was close. We'll move on. Still ahead tonight here on The Debrief. It's a question of accidental choking or abusive murder. Two foster parents stand trial for what they say was the choking death of a child in their care. Finally, the evidence we've been waiting for, which could mean the difference between conviction and acquittal. And now to the trial of a Georgia couple accused of murdering their 2-year-old foster child. Joseph and Jennifer Rosenbaum face a mix of murder and other charges related to the death of Layla Marie Daniel. Authorities say the little girl died from blunt force trauma to the abdomen, a cut pancreas, and other abuse. The defendants say the girl died accidentally by choking on a piece of chicken and that she was further injured during CPR. One question hovering over this case is how the victim was placed with the defendants in the first place. Key testimony came from a foster care case manager about how the defendants discovered the victim had died.
Once I got to the hospital, they put us in the, I don't know, it was like a little side room. And that's when the doctor came in and he spoke with me and informed me that she had passed away.
Was Ms. Rosenbaum or Joseph Rosenbaum present at that time?
Ms. Rosenbaum was present. Mr. Rosenbaum, he was on his way.
Were you in the same room with the defendant, Jennifer Rosenbaum, when the doctor informed you that Layla had passed away?
Yes, ma'am.
So he told you both at the same time?
No, he had pulled me out of the room.
Okay. So after he pulled you out of the room and told you that Layla passed away, what did you do?
Honestly, I went back in and I confronted her with the information that he had gave me.
What did you tell her?
That, well, for one, that she had passed away and that she had several bruises on her lower half.
And what was her response?
I honestly just remember her crying, and she seemed to just be in shock. She didn't say anything about it. She was crying majority of the time.
On cross-examination, the defendants asked the social worker if her records indicated the defendants were providing proper care for the victim.
You inquired and you looked at that mark on her forehead.
Yes, ma'am.
It was a scratch.
Yes, ma'am.
It wasn't a bruise.
Correct.
It wasn't a cut.
Yes, ma'am.
It was the type of scratch you get from falling down, wasn't it?
Yes, ma'am.
And you looked at it and determined that this was the normal type of injury that active kids get into, correct?
Yes, ma'am.
And in fact, there was ointment and a Band-Aid on it, correct?
Yes, ma'am.
You, in fact, on August 5th, 15, found that the Rosenbaums were doing a good job. Isn't that true?
Yes,
you wrote in your statement that.
Yes, ma'am.
The case manager agreed that the victim and her sister were growing, learning, and in many ways being properly cared for by the defendants. But listen to what the victim's great-grandmother said about conversations she had with the victim's sister.
She would sometimes get spankings with a belt. And I said, "Why didn't you tell your Nana?" She said, "Because Jennifer told me if I told you about the spankings, I'd get worse spankings." And she said one time Jennifer had made her eat some nasty tasting potatoes and it made her sick and she threw it up. And then Jennifer made her eat the throw up. She said that Jennifer would grab them by the arm and twist. She said that she would knee them in the stomach, and she demonstrated it, if I can do it without falling down. She went right in our tummies.
The defendants are trying to say the victim's injuries occurred during CPR. A number of first responders and doctors, however, who treated the victim say that is not likely.
Did you have any other concerns other than the cardiac arrest that caused her death?
Yes.
What was the concern?
Diffuse bruising up her chest, pelvis. Then when we moved her over, you noticed the back, kind of just top to bottom bruising. I mean, it's just an odd location. I mean, a child was going to get bruises and bony prominences. They fall, they hit their elbow, they hit their knee, they bump their forehead. They don't really hit their pelvis very good. They don't hit flat on their back and get multiple bruises on their back, or their neck. It was an odd appearance, didn't look right.
And in the over 100,000 patients that you've treated, have you ever seen anything like the bruising you saw related to resuscitative methods?
No.
There's the answer. No. This next officer testified about the story he learned from the defendants about how the child supposedly died choking on chicken.
Jennifer told me that Layla had been sick previously with some congestion and had just started eating solid foods in the last couple of days. Layla was in a high chair eating chicken tenders, I think she said carrots and some yogurt. Looked back and saw Layla kind of moving back and forth in the chair. She went over to check on her, thought she may be choking, took her out of the high chair, performed a Heimlich maneuver on her. She then took her over to the sink and started hitting her on her back. She said she hit her hard. She said at that point she tried using her finger to dislodge whatever was choking Layla, and also she used a butter knife to try to dislodge what was in the choking Layla.
Did she tell you when she used her fingers to sweep to dislodge whatever she was choking on? Did she tell you if anything came out?
She didn't. No, she said after doing those type things, she's already at the sink, so she took the faucet and tried to give Layla water using the faucet. That didn't work either.
And did she tell you what other measures she took trying to allegedly get something out of her throat?
After that point, she said during the whole thing, Layla was kicking. So at some point, she dropped Layla from about 1 to 2 feet off the ground. Once on the ground, she said she tried to perform CPR on Layla.
Notably there, the officer said that he was told the supposed piece of chicken never came out of the child's body. Now, logic would suggest that if that was true, someone would have found the chicken in her airway, but no one did.
So the signs that you would have been looking for was, I guess you said vomit or food or something like that in her airway?
Somewhere.
Did you find any of that with Layla Dane?
No, she was clean.
And I think the next thing you said was the coloration of her face. What type of coloration would you be looking for?
I'd be expecting something a little bit more blue.
Okay. And did you see that with Layla Daniels?
She was very pale.
And you indicated that you also were looking her eyes for hemorrhaging.
Yes.
That hemorrhaging that you would find that would be consistent with choking, did you find it here?
No, ma'am.
And then you said you would check for bruising.
Yes.
Because you didn't have a pulse. Is this what you observed when you saw her?
Yes, ma'am.
Okay. And in your medical opinion, was that consistent with the child who had been choking on a piece of chicken?
No, ma'am.
Okay, our panel is back tonight to discuss this case. Mike Koribanics, Brian Buckmire. Brian, I'll start with you. I just basically wrapped the case up in what, 5-10 minutes there. Where's the chicken if this is true? If the defendant's saying that the chicken never popped out and no one in the emergency room found the chicken, where's the chicken?
So from there, I think Mike actually articulated it really well in the last segment. You've got to kind of parse through what's being said. So the officer is saying that he was never told or never heard. Those are two very different things. In the slew of all this happening, a mother panicking, calling 911, as Mike said very clearly, the EMT was checking the throatway. Someone had the consciousness of mind to check for choking. So at some point in time, that information must have been conveyed. If it wasn't conveyed to the officer, it must have been conveyed to the EMT, it must be conveyed to someone. So just because you don't hear something, but Mike hears it, it doesn't mean that I didn't say it.
Okay, so Mike, is it possible here, despite what everybody's saying that we just listened to, that maybe this chicken was somewhere and it didn't leave any signs in this girl's esophagus?
It could be possible. I mean, I look at this almost, Aaron, as a chain of evidence. Nobody has tracked this child from the spot of choking to the hospital. Anywhere around there, this chicken could have been dislodged.
Okay, but look, I'm not buying this. Like, I know you guys are trying to do what you do as defense attorneys, and look, I respect you. I'm not buying it in this case, though, because chicken crumbles. It's not like, you know, a fork or a spoon or something metallic. I mean, a little shred of it would have come off somewhere and somehow have been detected, I would think.
So again, how you finish your sentence, I think. You're making assumptions.
Well, I'm saying, in other words, I'm not hearing evidence of it, and therefore I am not believing the defense case.
So this is the great thing. I don't have a case. I don't have a burden. I don't have to prove anything to you. It's the prosecution's job to do that. And what I usually do with the jurors is I make the analogy of they have to provide, not me.
Exactly. Okay, gentlemen, we have to wrap this up. Thanks a lot to both of you for being here with me. We'll continue this argument after the show ends. Have a good one, everybody.